No, no. Are you, how many of you are doing PowerPoint? Are you doing PowerPoint? You are. Okay, so what we may want to do is, some of us may want to be sitting there so that we can see your PowerPoint. Are you all doing PowerPoint? Lee, are you doing PowerPoint? Okay, so, all right. Well, good morning, everybody. Can you all hear me? This session is on environmental governance. If you came because you wanted something else, then you're in the wrong place. What we're going to do is we have three speakers. I'm going to introduce them all very briefly, and then we will do speakers in the order in which they're listed in your program. Our first speaker is going to be Nikki Broekhoven of Ghent University in Belgium. She's going to be speaking about gender in the Rio Conventions, as you see in your program. The next speaker, also from Ghent University in Belgium, it must be nice to have traveling companions, this is probably very good, is Niels Houtien, who's going to be talking about legal challenges in the creation of a World Environment Organization. That's an issue that you heard about a little bit in the earlier program. And then finally, Li Jiping, who's with Sen University in China, will be talking about the main track of the development of environmental framework law, from the Conference on the Human Environment to the Conference on Environment and Development. They're each going to be speaking for about 20 minutes, and then we're going to have about 10 minutes at the end for questions.
Okay, good morning everyone. My name is Nikki, and I'm a PhD student at the Department of Public International Law of Ghent University. And what I would like to do today in the next 20 minutes or so is really give you an overview of the integration of gender issues within the 3 Rio Conventions. So we will start off with a background on gender and the Rio Conventions. But before I do that, I would like to start with 2 crucial concepts. One is gender, and the other one is gender mainstreaming, because they are 2 crucial concepts for my presentation, and I don't know if you are familiar with those. We will look at some examples of the link between gender and each of the Rio Conventions, so gender and biodiversity, gender and climate change, and gender and desertification. We will also take a look at the integration and mainstreaming of gender within each of the separate Rio Conventions. We will see if gender is incorporated within the cooperation mechanisms between the conventions, and then we will look at some positive changes and ways forward. So, as we all know, biodiversity loss, desertification and climate change really pose unrivaled global problems at the moment. And their impacts will be felt by everyone on the planet, but especially the poorest people in the world will be most affected. But the same way as there are kind of disparities along the poverty lines, there are also some disparities along the gender lines, which means that the effects of desertification, climate change, and biodiversity, they are not gender neutral, so they have different impacts on men and women. So we'll take a look at that. Now first, one of the crucial concepts, and the first one is the concept of gender. Gender, as you can see, I put a definition on this slide here, is really about the socially constructed roles between men and women, and about the power relations that are associated with it. Now, it's important to emphasize that gender is not a synonym for women, because often when people think about gender, they immediately start thinking about women. But gender is really about addressing both the needs and concerns of men and women, and also boys and girls. Now, if we want to reach true gender equality, it's important that we, of course, also integrate the concerns of men and boys, because they really play a very crucial part. And this has been increasingly recognized by the UN, and as we will see, also by the Rio Conventions. But of course, when you hear about gender, a lot of focus is often on women. And because of existing gender equalities, often you need to pay specific attention to the most vulnerable groups. And when it comes to gender and environment, often it's the group of women and girls. Now, if you want to reach gender equality, it's important that you have a strategy in order to reach it. And the strategy which is mainly used is gender mainstreaming. Now, gender mainstreaming is really a strategy that aims at transforming the unequal and the social and the institutional structures by recognizing that gender equality should really be the key driver in the process. So gender mainstreaming is not really about adding some gender issues or adding women's participation to it. No, it's really about changing these systems from within. Gender mainstreaming so really entails that you bring in the experience, the knowledge of men and women, and that you really include that in policy making, in planning, and in decision making. Now, let's give some examples on the link between gender and each of the Rio conventions. For example, gender and biodiversity. When you look at the maintenance of local level biodiversity, you see that it's often maintained through the knowledge and the know-how of both men and women. But it's not maintained in the same way. Men and women, they have a different knowledge about biodiversity conservation, for example, about plants, seed, animal genetic resources. But they also have a complementary knowledge. So if you want to address projects on biodiversity conservation, it's important that you really include both the knowledge of men and women, because otherwise you will lose out, of course, on crucial knowledge, and a lot of your programs and projects will go to waste. The same for desertification. Because of the gender roles that exist within rural communities, men and women, they perform different tasks. And I'm generalizing here, but often it's women who take care of searching for food, fodder, water. Depending on the culture, it can be women or men that really take care of the animals. And when it comes to commercial production, for example, of fodder, and wood, it's often men who are included in this process. So also here, it's really important to look at the different roles between men and women in setting up desertification projects. Also for climate change, we see a lot of extreme weather events, and they cause a lot of deaths, and they cost a lot of lives, but this has a different effect also on men and women. And for example, this depends really on the means that they have at their disposal for securing their own safety. A lot of case studies show that women, for example, are most often the losers, or they lose out most often in case of extreme weather events. Now, let's take a look at gender and the Rio Conventions. Gender has been recognized at the international level for numerous years. It has been recognized in several international legal and policy documents. For example, in the first Rio Earth Summit in '92, we saw there was a whole chapter on including women in action in Agenda 21. Although it was a broad recognition, we also had Principle 20 within the Rio Declaration, and we see that 2 of the 3 Rio Conventions really included gender issues from the outset. So when we look at the different conventions, for example, the Biodiversity Convention, it really included the important role of women and the importance of their equal participation within the preamble. The 2 protocols to the CBD didn't make, only the Nagoya Protocol makes mention of gender issues. So the Cartagena Protocol, although it can have different effects on men and women, like the biotechnology can have, that doesn't include any gender issues. But even though gender was really mentioned in the preamble, the convention didn't really develop any further on this, at least not in the first 10 years. So what I've did is I've looked at the different outcome documents of the Conference of the Parties, and there you can see that the most reference to gender were really included since 2002. And it's interesting to note that the gender issues were really included through the lobby work of the indigenous groups on Article 8G of the Convention, which is on traditional knowledge and innovation practices. Whereas the Convention on Biological Diversity first really focused on women and women's issues in the beginning, we see a change after 2007, where it started really focusing on gender and trying to involve also men in this process. We have a gender plan of action that came out actually in 2008 with the help of IUCN. And this gender plan of action really kind of put forward a plan that could be developed by the Secretariat of the Convention to start a process of stimulating and facilitating both in-house and also with external partners the process of overcoming constraints to gender equality and really grabbing the opportunities there are for reaching more gender equality. The decision on gender mainstreaming really built onto this, and it acknowledged the importance of gender mainstreaming within the programs of work under the CBD, and also within executing its strategic plan for 2011-2020. For the UNCCD, it was actually the convention that had the strongest recognition of women's issues and gender issues from the outset. It really encouraged not only the full participation of women, but really the full participation of both men and women. And it was the only convention that has different gender aspects throughout the convention text, so not only in the preamble. So after the convention, there were several COP decisions that reiterated the relevance of gender, and most of them can be found in relation to gender balance in, for example, expert panels, and also on gender in developing the national action plans. Recently, in 2011, there was also an advocacy policy framework on gender that got adopted, and this framework really builds on the experiences with the Biodiversity Convention Gender Plan of Action, which was developed in 2008, and it really mirrors a lot of the things that were included there. And it's also a tool really that provides the Secretariat a mandate to deal with gender and to include gender in the implementation of the projects and the programs. When we take a look at the UNFCCC, that was actually, in terms of gender, the worst of the 3 Rio Conventions, because for a long time it didn't make any mention of gender or gender issues, and to some extent today a lot of the climate change discussions are still gender blind because they focus too much on the technical issues, the scientific issues. But the real turning point for including gender really came at COP15 in Copenhagen, where there was 8 references to gender within the outcome document of the ad hoc working group on long cooperative action. But the problem was there, gender issues were still missing in mitigation and financing. So what the Cancun agreements did, they really reiterated everything was said at COP15 in terms of gender. And then the real breakthrough came at COP17 with the Durban platform, where gender references were not only reiterated, but they were also included in the finance section of the Green Climate Funds, and this financing part is really important as well. So if we take a look at a short overview, we can say that the CBD now really has a strong mandate for including gender issues within its work. It has a strong gender plan of action, and it has a decision on gender mainstreaming. It really is a mandate for including gender into all programs of work, and in its strategic plan for 2011-2020. What the CBD has been doing is working on developing mechanisms and tools for starting to implement all these gender references. But there the work, there's still a long way to go in terms of implementation. For the UNCCD, we also see that there's a strong advocacy policy framework on gender since 2011, but there they now have a stronger mandate to work on gender, but the implementation efforts there really still have to start, because they still have to start working on this gender plan. For the UNFCCC, a very positive change is that at least now we have gender language that is included within the framework of the convention. Some negative points is that gender is still missing in the mitigation part, because there's only a reference to women, so not specifically to gender, and it's still missing in the Kyoto Protocol. And unlike the other 2 conventions, with regards to climate change, there still is more focus on the vulnerability of women, rather than as including women and men as agents of change. So let's take a look at the cooperation between the conventions, because, as you know, all the conventions are really interrelated. They wanted to work closely together to cooperate in different areas of work. And so they really use gender as a way to increase this cooperation between the conventions. Gender has, for example, been dealt with by the Joint Liaison Group, which is really like a platform with an aim of strengthening the cooperation between the 3 Rio Conventions. And it has also been dealt with at the Rio Conventions Pavilion, which is a collaborative outreach activity which takes place at different crucial summits. And the last one was, for example, at Rio+20, where there was a whole day really on gender mainstreaming within the Rio Conventions Pavilion. And the 3 Rio Conventions now have a harmonization roadmap to mainstream gender within the conventions, because they really decided that they wanted to move the gender efforts forward. And they have a vision on that in the roadmap, and it says that they want to live by 2020 gender as a cross-cutting priority, and they also want to ensure that it is integrated into thematic issues across the Rio Conventions and the GEF to achieve the long-term objectives of the 3 conventions. So, as you will have noticed, there are a lot of positive changes and things that have shifted over the years. Something that is very positive is the shift from women really to gender issues and to more to gender equality. Because of course it is very important, and especially at the local and the national levels in projects that where women and men are already working together to conserve biodiversity, to address desertification and climate change, that we translate that to the international level as well. In terms of a mandate, because of all the gender action plans, the decisions on gender, there has been stronger mandates, and there really have been spaces created so that the secretariats can really address gender. For example, they can speak gender language, they can hire gender specialists, they can do gender trainings. And what you also see is that there is a stronger commitment at the top level of the conventions to really move forward on these gender issues, something that wasn't there in the beginning. In terms of implementation, the efforts really have increased. We can see that, for example, for biodiversity, in national biodiversity action plans, there needs to be attention paid to gender issues. It's the same for desertification in the national action plans. But in terms of implementation, and not only on gender, but in general for environmental law, a lot still has to happen. But I think that because of the strong mandates and the gender references that we have at the moment, we will at least have some, like a solid framework to move forward. And that brings us to the last point, which are the possible ways forward? Well, my presentation started with a question like, is the road for gender mainstreaming within the Rio Conventions getting less bumpy? Well, in general, we can say that the road has definitely become less bumpy, but that the work is not over. As we heard this morning, we really said no regression, and this also counts for gender language. There's really no regression allowed. What we saw at Rio Plus 20 was that a lot of countries were really starting to question the gender language, especially about sexual and reproductive rights. But in general, the whole framework started like to wiggle a bit. So it's important that the gender language we now have is kept in place. We need to increase efforts on implementation. And for that, it's important that we can build on strong mandates, but the implementation is just a black hole when it comes to gender and the Rio Conventions. And last but not least, it's very important that we try to amplify the voice of the most vulnerable, because women and men are doing crucial things at the local levels to conserve biodiversity, address climate change and desertification, but those voices are not heard at the international level, so there's no way to include their experiences and knowledge. So it's really crucial that we take their voices into account, because they have something to say and they have very interesting information to share. So thank you for your attention.
Thank you for that really quite wonderful presentation. It was, I thought, nuanced and analytical, and certainly on my end, very, very interesting. Our next speaker is Nils Houtin.
Okay, thank you, Chair. Good morning, ladies and gentlemen. My name is Nils Houtin. I'm also part of the Department of International Public Law of Ghent University. I'll be speaking about the legal challenges in the creation of a World Environment Organization. What I will do today is talk you through the reasoning behind the paper that I've written. What is it exactly that I tried to do? What is the findings are? And before I can do that, I really have to go back to some of the things that have been said this morning in the opening session on the Rio Plus 20 outcome, especially on the International Framework of Sustainable Development. I will then talk a bit more about the background of the paper. And then when we talk about legal challenges in the creation of a World Environment Organization, we need to know what is a WEO. So we will need a working definition. Once we know what it is, we know what it is that we need in order to get there. And once we know what it takes to get there, we will make an assessment of what exactly will it change compared to the situation of today. So first, about Rio Plus 20. We've heard a lot of presenters this morning saying, well, the outcome was, a bit of a disappointment. And I think that they're correct. And especially in terms of the International Framework on Sustainable Development, I think that the outcome is very disappointing. In the zero draft, there were two alternative paragraphs 51 on UNEP and on the future of UNEP, which is United Nations Environment Programme. And the first one said that we will strengthen the mandate of UNEP by establishing universal membership of its governing council, and by increasing its funding and by enhancing its mode of implementation. The second paragraph said exactly the same, only it added that UNEP would be upgraded to a specialized agency. Now, unsurprisingly, what came out of Rio Plus 20 was exactly the first paragraph, saying UNEP will have universal membership of the governing council, increase financial resources, and enhance modes of implementation. What was remarkable to me is the fact that there are no further negotiations processes planned on the future of UNEP, on what exactly it is that we want to do with that organization. That is surprising because over the last 40 years, there has been a debate going on about what should UNEP do, what should it look like, what should its mandate be, what should its format be. And we all know that the overarching theme or the overarching mantra of environmental governance is that form should follow function. There's been a whole debate going on about what those functions should be. What is it that we expect from UNEP at the international level? So actually the Rio Plus 20 conference, the sort of overarching theme was the future we want. But it seems that in terms of environmental governance, the future we want sort of looks like the past we already had. It's going on to be the same thing. We won't change anything. So what I did as a background for this paper, I made the constatation that there are over 17 different proposals for a World Environment Organization. And some authors talk about we need a WEO based on the World Trade Organization, sort of to balance out economics and environmental affairs. Other authors have said, no, we need to talk about a World Environment Organization as an ILO, the International Labour Organization. Why? Because there, and the overarching theme of this panel is legitimacy, because in the ILO we have better measures to enhance legitimacy, to enhance the outcome of decisions. Remarkably, these two, so the WTO and the ILO formats proposals, are very much academic. And there is very little political enthusiasm to actually implement it. Whereas the other two, the UNEO proposal, which is the United Nations Environment Organization, and just to be clear, UNEO and WEO of Global Environmental Organization, no matter what you want to call it, the idea remains the same. The UNEO proposal is a political proposal by the EU and especially France, actually. And the umbrella organization, again there, the only thing that I really found of substance was the nice picture over there. But apart from that, what exactly it means is not very clear. So the first two proposals have been worked out, elaborated by academics. The second two are political projects, but do not have a lot of detail. We don't really know what it is that they will do. So I came to a sort of issue-based definition of a World Environment Organization. And it is clear from all the different proposals on the table that we are convinced that a UN specialized agency would be the best option. That is the way forward. And it should provide an umbrella for the existing multilateral environmental agreements. It should provide a high-level policy forum. And it should help strengthen capacity of countries meeting with implementation and compliance issues. So once we know what it is that we want, which is this, apparently, a World Environment Organization as a specialized agency with these 3 specific tasks. I made an analysis of what it is that we need from a legal perspective to actually get there. So I will go over these 4 points. First of all, UN specialized agency, it's quite easy what we need. We need a multilateral treaty establishing the organization, which is a constitution. And we need a relationship agreement between that organization and the United Nations proper. Whether you do that by the General Assembly or the ECOSOC Council, doesn't really matter all that much. So legally speaking, that's not really difficult to do. You just take a look at the procedures that are established in Articles 57 and 63 of the Charter, and that's it. Legally speaking, there's no big issue. Now, if we take a look at the functions and take a look at what is legally needed, there it becomes more difficult. First of all, if we say that we need an umbrella for the multilateral environmental agreements, what exactly does that mean? Does that mean that we sort of encompass all of these MEAs, the more than 500 that are in force, and that we will do what? Have similar functions, create one common secretariat, for instance, create one common compliance mechanism, for instance? What is it exactly that providing an umbrella means, especially in light of the legal problem that all of these MEAs are legally autonomous? So it is the parties to the conventions and the COPs that are responsible for the development of these MEAs and of the further development of their framework. We also need to provide a high-level policy forum. Well, that is something that can easily be done. Legally speaking, it's not really difficult. It's more of a political issue. Actually, UNEP did something very similar in 2000 when it established the Global Ministerial Environment Forum, which is until today the only global ministerial consultation that convenes regularly. So legally speaking, there's no issue. And then enhanced capacity building efforts, where there it became quite obvious that UNEP is only one of many players in the field that is responsible for capacity building efforts. And the WEO should be able to coordinate those. So after making that sort of analysis, the question came to mind, what exactly is it that will change if we have a WEO doing these tasks instead of UNEP? So what is the added value of a World Environment Organization to the existing framework as we know it today? And so I'll go back to the former slide, to this one, because if we take a look at the functions for a WEO, you will see, I hope, I will make the argument at least, that the WEO won't actually change all that much. Providing an umbrella for the existing MEAs, we know that there are ongoing clustering efforts between a number of the MEAs. For instance, in the chemicals cluster, there are a couple of MEAs that work together. Now, it is quite clear from the experience that we have there and the negotiations that are going on, that countries are unwilling to have an international actor steer these processes. That means in practice that clustering MEAs is a bottom-up process that cannot be steered top-down. And it doesn't really matter whether or not your international actor is UNEP, a program, or WEO, an organization. It doesn't change anything to the dynamics that is in place, namely that it is a bottom-up process where countries are in charge. The High-Level Policy Forum already said that UNEP actually did take already an initiative in 2000 in this regard. And it is more of a political issue of countries saying, well, if countries feel that something more is needed, that we need to convene more regularly, then that is something that can very easily be organized also by UNEP. You don't really need a World Environment Organization to do that. And last, the capacity building efforts. Well, it is true, politically speaking, that a WEO could potentially bring in more money than UNEP can today. Granted. The question is more whether or not the coordination of all the existing initiatives is something that can be done better by a WEO. Like I said, if you talk about UNDP, about GEF, about the different funds by the MEAs, about the different funds that are governed by UNEP, I think it's very difficult to say that if you change one of those actors, namely UNEP, into a World Environment Organization, then all of a sudden all the others will be much easier coordinated. That doesn't make sense. If you want to have global initiative on these capacity building initiatives, that means that you would have to change all of these organizations that are busy with that. And that is something that I think will not happen. So the conclusions is that basically if you compare the World Environment Organization as a specialized agency versus what we have today, a United Nations Environment Program, then based on the functions, there is not really a big difference in what the WEO could do that UNEP cannot. Based on format, that at least in terms of decision making, clustering and funding, there's not much difference between a World Environment Organization and a UNEP, excuse me. And then, this is something that I added last night, because the overarching theme of this panel is legitimacy. So the decision is now that there will be universal membership of the Governing Council, whereas I don't know if you are aware of how UNEP actually works and takes its decisions. But UNEP is a program that means that there is a Governing Council, a small group of countries. For UNEP, it's 58 countries. 58 countries that are elected from the General Assembly to take a seat in the Governing Council. Now, in theory, that means that UNEP takes decisions based on what those 58 countries want, and that all of the other countries are not involved. In practice, UNEP takes its decision based on what we call universal participation. That means that even though, officially speaking, legally speaking, there are only 58 members of the Governing Council, all UN member states have a right to take a seat in that meeting and to have their voices heard. Also, NGOs, civil society, have the right to be in those meetings and to actually have their voices heard. So the fact that we now have universal membership is a nice window dressing tool, but in effect it will not change anything in terms of legitimacy or legitimate outcomes of the decisions of UNEP. And I also would like to point out that if you change United Nations Environment Program to a World Environment Organization, then you take out the process where UNEP takes its... So, let me rephrase that. UNEP takes its decisions based on the consensus in Nairobi, and then its decisions are forwarded to New York, where in the General Assembly they are reaffirmed. So basically you have two processes. You have the negotiation process in Nairobi, and you have the negotiation process in New York. In both processes, NGOs, civil society, are represented. If you take out if you change UNEP into a World Environment Organization, then you lose one of those two steps. And that means that you lose one of the two possibilities for NGOs to actually have their voices heard. So in terms of legitimacy, I think that the way that it is organized now, with universal participation and with a United Nations program, is actually better than changing it to a World Environment Organization. Contradictory, but I think it's true. So that's what I wanted to share with you. Thank you very much.
Well, that too was quite good, and I think provides a lot of food for thought. We're sort of moving from the rhetoric, if you will, to the specific functions and to what it would actually get done. So our final speaker, Legitimacy.
Thanks for chair, and good morning, ladies and gentlemen. Today's my topic is about environmental framework law. This presentation is based on a research project given by Chinese Education Ministry. It's about comparative research on environmental framework law. Maybe most of you don't know that China is trying to amend their environmental basic law for many, many years, but now the progress is very little. The research project is trying to find out what's the development trends in other countries and try to find out was the newly development of other countries. So-called environmental framework law, in China we also call it environmental basic law. And this term, basic law, is more often used in Asian countries like Japan, Korea, and China. But usually it is not the same meaning with your often understanding the word basic law in Germany. It means the constitutional law, but in China it means that the framework law. And it refers to the comprehensive legislation about general issues of environmental protection in the countries, such as basic principle, basic policy, mechanism, system, and right and obligation of environmental protection. It functions as the core of environmental law system, which leads, guides, and coordinates environmental sectional laws. Looking back to the development of environmental law, there are two phases of law reaction to environmental problems. The phase one is to solve environmental problems via enlarged traditional legislation. Environmental problem was considered to be the problem that people unproperly use their property or unproperly to distribute people's rights. So in the early stage, people just adding regulation in property law, tort law, and criminal law to solve this kind of problems. And in phase two, to create environmental law to deal with environmental problems. And this phase also can be divided into two subphases. The first one is since 1940s, to make environmental sectional law to deal with different kind of environmental issues. In that state, due to the limited knowledge about the reason of environmental problem and relationship between different environmental issues, so usually the legislation adopts separate reaction by classifying different problems and then enacting different laws and regulations according to their different characteristics. And that phases that we create a lot of sectional environmental law like pollution prevention law, natural resources law, environmental management law, etc. And in the subphase 2, since late 1960s and early 70s, more and more environmental framework law appear. The reason for the creation of environmental framework law are mainly as follows. That means that the integrated protection instead of separate protection. People have realized that the limitation of separate method to deal with different environmental issues, and then realize that the relationship between different environmental problems. And then the second reason is about the reaction to increasing serious environmental threat. In the early stage, very few governments really have the far-reaching strategy that to create the environmental law. Most of the environmental basic law are created to solve the very urgent environmental crisis. The third reason is to promote national environmental principle in environmental policy. In order to get more attention from the society to stress the environmental issue, countries need to upgrade their environmental principle and policy by creating low-level environmental law. And then the last reason is to integrate, and coordinate the seasonal environmental single laws. And the development of environmental framework law can be, we look back to the tract of environmental framework law. We can see there are two peak periods. The first peak is since from the Stockholm Conference from 1972 to mid-1980s. The second peak is from 1992. This is the Rio Conference until now. So this means that these two important conferences really have a very, very important impact on the development of environmental framework law. Why the Stockholm Conference has such important impact on environmental framework law? If we look at the outcome of this conference, that it created 7 common understanding and 26 principles, and then it bring a lot of new shock to the environmental law development. It treated environment and environmental protection through systematical viewpoint, and it proposing people's basic right in environmental protection, and it clearly specify national and social environmental responsibilities and forwarding national strategy on solving environmental problems and demonstrating fundamental environmental protection principles. Almost every country, no matter developing country and developing country, all realize their environmental development was seriously influenced by this conference. And actually, China's environmental law is also the modern environmental law also start from this conference. And during this period of time, environmental framework law from development from zero to a very priority, and which is create a very significant leap of the environmental legislation. But in this period of time, environmental framework law is still quite simple. It's a policy-basic characteristic, which is mainly include national environmental protection target policies and demonstration of countries' and enterprises' environmental protection liability, and to establish national environmental administration and its function. So the content is still very simple. And during in the second period, as it start from the Rio Conference. The Rio Conference have a very, very important role to the development of environmental framework law, and the most important contribution is to establish the sustainable development strategy. And in order to realize this important strategy, many countries create a brand new environmental framework law and also to modify their original environmental framework law and made the second peak of the development of environmental law. And in this period of time, environmental framework law become more and more comprehensive and also increasingly diverse form. Sustainable development become the basic and also the priority target on environmental framework law. And citizens' environmental rights develop into core rights in the environmental law, and the system of environmental law subjects' rights and obligations are essentially mutual, like the public participation, the right to access information, become very mutual. And in this period, established framework to for environmental governors and strongly advocate social participation by multi-subjects. Many economic basis measures are being adopted. Environmental liability and judicial remedy mechanism were improved a lot. And so, under a review of these two peak period, we can make a conclusion that the basic condition for development of environmental framework law are at least have such follows as follow. First, we need to have an ideology preparation. Then, means we need to prepare the new shot, new ideology, and then enough to create a revolution of shot. And this new shot can be understood by universal. And the promotion from international society is also very crucial. This is the outside driving force. And then the stress from domestic environmental crisis is also very important. And this is the inside driving force. But in the early stage, in early 1970s, many important countries like China, India, and Brazil, I think their environmental framework laws development are mainly driven by outside force, international influence. And I can say only after 1990s, when the environmental issue become really serious in these countries, then the inside driving force become the main forces. And as for the contents of environmental framework law, we can see such trends. That is the technology centrism replaced by the interest balance centrism. In the early stage, the main method to cope with environmental issues are based on technology, but now more and more considerations are based on the interest balance by creating people's rights and to balance different group people's rights. And then the government dominate model becomes the social participation by all kinds of subjects, and the mandatory control basic governance to become multiple control methods, and then the supervision process from emphasize beforehand and become to a more comprehensive control in beforehand process and afterward states and relief methods. That is the whole process management. And the environmental framework law in different countries are very different. And no matter the content and the structure, and some commonness can be seen. I divided the there are several groups, and in Asian countries, mainly belong to environmental policy law group, and in these countries, environmental framework law are still very simple, very principle and abstractive. They function as a policy, many address policy issues. In African countries, they belong to the environmental management law group. Then the law are more and more detailed, and the content become more and more comprehensive, but it's still mainly focused on government's management. And European countries, I think they belong to environmental codification or semi-codification group, because many countries have already enact their environmental code, and more and more countries create more and more comprehensive environmental framework law that is like a semi-codification. But more and more commonness are created, and I think it's because the people to cope with the same environmental problem, to face to learn from each other. So they have created more commonness in environmental framework law, like common goal, common concept, common principle, system, and liability. Is that true? And I want to give a very brief introduction for the Chinese environmental law. Chinese environmental framework law was created in 1979, and this law was replaced by existing environmental protection law in 1989. And since then, there are no any amendment to environmental framework law in China, and making it far behind social development and the general level of global environmental framework law. We also call this law like a sleeping law, almost a death law, because they play very little function in environmental protection. Thus, it means that China has catch up the first peak of the development of environmental framework law, but missed the second peak. Why the development of environmental framework law so slowly in China? The reason include the fierce competition between economic and environmental protection. For about 30 years, China still are development dominate countries. So the environmental protection still are very weak part of the development of the country's strategy. And also the power competition between different government agencies, because the government don't want the environmental protection involve many government agencies. no government agency want to lose their power by amending environmental law. So it's a very sensitive issue. The last reason is the government's policy, environmental policy and seasonal legislation have really replaced the law of environmental framework law in some extent. But the development, the opportunity to improve Chinese environmental framework law is still exists because China now have already forced a social common understanding to protect environmental issues, and then the government has proposed many new strategy and also new law to deal with these issues. I think it's now a very good opportunity for China to upgrade their environmental framework law. I will give one more information to you is that China is amending its environmental basic law now. We are looking for the new context of this law. Thank you very much.
Well, thank you. That was very informative and a little bit of good news right at the end about what China's up to. So we've heard presentations on gender, on a World Environment Organization, and sort of framing the larger picture internationally on the environment in the context of what China's been doing. We have a few minutes for questions, and so go ahead. Yes, sir.
This is a question primarily for Professor Lee. I know that the framework law has been under discussion for some time, and I have heard that in January the draft that was under discussion was significantly changed in a manner that was disappointing to many in the NGO community in China. And many perhaps also in the academic community as well. One provision that I'm particularly interested in was the draft provision intending to give greater standing to NGOs or to social groups to bring litigation. And I understand that there was also a parallel provision under the proposed amendments to the Civil Procedure Law. I'm wondering whether you can update us on whether there have been any changes in the posture of either of those two laws since January, because that's the last time I heard anything, and I'm hoping that other people have heard things since then. And just to do a hook to connect it to Rio, you know, Rio had 40,000 people there showing an overwhelming interest of grassroots folks to become involved in environmental issues, and I'm sure that there's no difference in China.
Thank you very much for your questions. Actually, the amendment draft is really disappointing many academic and many NGO because it didn't make a fundamental change to the framework law. It only proposed some amendment in some critical issues. But the provision of public participation and public interest litigation is a very attractive provision. And this draft, and I didn't see the last draft, but for my knowledge, I know this provision have no change. And then, except the new proposal, actually in practice, the NGO and government agency have actually bring a lot of lawsuit to court, and then the results are very positive. Then encourage the legislature to maintain this provision, and even more they will make maybe other legislature to make it detailed. And you know, China has already lived the condition to create NGO in China. Now, from my home city, now more and more NGO have been created, and the government actually encourage them to involve to more and more environmental issues now. It's a new development.
Other questions? You know, just for everybody's benefit, why don't you identify yourself and where you're from? No, I'm sorry, I should have asked you as well. But
Should I identify myself?
oh, sure, retroactively.
No, I decline to. No, I'm Timothy F. I'm with the Office of General Counsel for the U.S. Environmental Protection Agency.
Okay. Yeah, my name is Wen Shang. I'm a PhD student at Carey University at the Environmental Center for Environmental Law and Energy Law. And my question, actually, I have two questions. Is it okay?
Yeah. I think it's okay.
Okay, yeah, I'll take this as one sheet. Okay. One question probably is relevant to the previous question. Actually, I would like to ask something about the public litigation issues in China. As far as I know, there are some good initiatives about the creation of environmental courts in some actually local areas of China, especially in the southwest of China, in some provinces like Yunnan. I would like to know if you could update my knowledge on these environmental court issues. And how does it work? And how does it take the case related to the environmental damage issues in China? And the second one goes to news. Actually, I think your topic is quite challenging, actually, for the creation of the WEO, the World Environmental Organizations. I know that definitely it will be under pressure from, let's say, internal and as well as external. That's to be a specific, for example, as GMO issues, which is my focus for research. Let's see, as we all know, there was a case a few years ago about GMO dispute in WTO. It's really under pressure for this WTO to take into account those, Cartagena Protocol, as well as the precautionary principle. And do you think, let's see, the creation of this WTO could solve, let's see, the external, especially these external pressures from outside? Or do you think, let's see, the conclusion in your presentation, the UN programs can be better, can be a better way to resolve these conflicts, let's say, between the trade and the environmental issues? Thank you.
So there were two questions. Let's take them in order.
Okay. Thank you for your question. Before I come to the United States, I just attend a conference, a forum, that is Environmental Judicial Forum in Beijing. And this forum it's mainly focused on environmental judicial problems, and about 80 participants from different corps attend the forum. And some of them are from environmental corps, some are not. And there are about 60, maybe more than 60 environmental corps being created in China. And many of them operate quite well, but some of them still have very little cases. But as I know, that the important influence for this environmental core, that they create many new mechanisms to deal with environmental issues. They have created many new methods, new procedure, and new and even the new how to say the 体制上的问题 the mechanism. Yes. Yes. So I think that the environmental core really play a very positive role in trying to promote Chinese environmental judiciary. This is the update.
May I? Actually, for the topic of environmental framework law, I think there are three pillars. One is environmental regulation, another is environmental litigation, and the last was environmental tort. Secondly, for the environmental public interest litigation, tomorrow morning I will give you a very specific talk, tell everybody interested in that how the environmental tribunal works and what institution functional they have played in China today. So I give the microphone to the doctor, future.
Okay. The question was about GMOs and World Trade Organization and conflict between trade and commerce and environment on the other hand. I think in my talk I said that a lot of proposals envision a sort of WTO for the environment and therefore envision a WTO. But the main reason that a lot of people do that is, of course, because the World Trade Organization is a very successful dispute settlement mechanism and has the powers and means to financially punish countries that do not comply with certain rules, and therefore is a very strong organization. And that is basically the idea behind we need a World Environment Organization, basically because in trade and commerce we have the means to enhance implementation and we lack them in terms of environment. I do not really think that there's a conflict between trade and commerce and environment, and I think that the GMO case is primarily an economic question, where the World Trade Organization has taken into account certain environmental aspects of the WTO. And I think that a World Environment Organization as such, compared to UNEP, would not have any more means than UNEP has today in terms of enhancing implementation or compliance with GMO and all other sorts of regulations. So I don't know if that's an answer to your question.
We have time for maybe one or two more questions.
I'm De Jinggu, come from Sun Yat-sen University. My colleague, Professor Li. I'm interested in the topic of WEO. The topic you have told us, I think, is very ambitious. Actually, I agree with you the proposal and the seeking, but I think it's very difficult and facing a lot of challenges. How do you think about change to another methodology to think about this? How that is impossible? For example, the Claudia appeal case in the context of Kyoto Protocol. I mean, according the UNFCCC give a decision, give Claudia for the base year, for the base years, for the emission amount of base year 1990 entered 3.5 million tons, but the Committee of Compliance of Kyoto Protocol doesn't admit it. The Committee of Compliance of Kyoto Protocol said, I have no authority to commit it. So my question is about how the WEO to promote the settlement of dispute.
Dispute settlement might be one of the core functions for a World Environment Organization. I take your point. If you say about new methodology and something that that the Kyoto Protocol and a sort of punishes, is that the way that you presented it? Because I'm not 100% sure if I understood the question correctly. But you say that the Kyoto Protocol is an exception and punishes countries, or what was it that you tried to?
I mean the new methodology is to avoid the challenging and difficult. That may be more easy to make it out. For example, the Montreal Protocol is very successful because the problem they try to resolve is very easy, just for the ozone.
True.
But if you want to create a WEO and then put all kinds of the treaty together, for example, using FCCC, so the implementation becomes more difficult.
Yes, absolutely. That is one of the main reasons why a lot of the MEAs are not willing to go into that story, are not willing to commit to that, because they say because each MEA has its own rhetoric, its own negotiation process that is ongoing, its own COP processes, and so if you want to capture all of those MEAs together, then you sort of thwart all of these individual processes, and so it will make in a lot of cases implementation more difficult.
Yeah, your presentation is very inspiring. I would like to talk with you later.
Sure.
Thank you.
Well, I think that's probably a nice note to end it on. I have a question for Nikki actually, but I think I think it's probably time to go. We adjourn again we start again at 1:30. Have a good lunch and thanks. Let's give a round of applause to all of our great, really good speakers.